Assalamualaikum and hi, we are from Group 2. My name is Aika Binti Abdul Rahmad, matric number 272051. And my group member is Adriana Binti Zamri Ali, Goh Yong Seng, Fatnin Nadiah Binti Yunus, and Hafizhah Binti Azeli. Assalamualaikum and hi, my name is Aika Binti Abdul Rahmad, matric number 272051. I will present the part 1, which is the case situation. First, the party that involved in this case are NAJAH AHMAD as the claimant vs Konsis College Sendirian Berhad as the respondent. The issue that led to the dispute is the claimant claiming that she has been subjected to constructive dismissal after she returned from her maternity leave because the company has committed breach of her employment with the company. Not only that, but the company also issued many warning letters and also memos about various misconduct to the claimant after she returned from her maternity leave. Not only that, but the company has issued many warning letters and also memos about various misconduct to the claimant after she returned from her maternity leave. Next, for the location, the organization was located at Ampang Jaya, Selangor, and their nature of business is to provide construction and industrial safety training. The case was first heard in Industrial Court on 4 September 2018. Lastly, the claimant's last position held in the company before she considered herself as constructively dismissed was HSE assistant. Next, I will present the case chronology. On 1 March until 2 May 2016, the claimant has taken maternity leave for 2 months, and on 11 May, the claimant was moved from level 5 of the company office premise to a smaller room on level 3 without her consent. And not only that, the claimant position also has been redesignated to HSE counselor from the manager of international HSE program, which is contrary to her previous job scope. Next, between December 2016 to January 2017, the claimant announced her second pregnancy. Then, after she returned from her maternity leave, this is where all the issue that caused the claimant to feel that she has been constructively dismissed begin. This is because she has received various warning letters and also memos alleging her with various misconduct. Next, in 2017, which is on 6 March, the position of the claimant as HSE counselor was abolished and the claimant was demoted to the position of HSE assistant and her salary also being reduced from 6,000 to 1,500. Next, on 9 March, the claimant had informed the company that their previous action was conducted as a breach of her employment and asked the company to rectify the breach allegation, but there was no reply from the company. Then, the company sent a letter to the claimant that they will withdraw the letter regarding the abolition of the claimant position and the reduction of salary, and they will retain the claimant position as HSE consultant. But she has considered herself as constructively dismissed by the company, and the matter has been reported to the Industrial Relations Department.
Hi, I am Fatnin Nadiah. So, for part 2, issue to be addressed. First, whether the present case is constructive dismissal or not, demotion to HSE assistant and significant wage loss were clear breaches of contract. Second, whether there is any evidence that the claimant was employed on a fixed-term contract. The claimant was hired for 3 years and the renewal of her contract depends on her performance and dedication, according to her employment letter. Third, should the company eliminate the claimant's job and demoted her? So, the claimant was demoted from HSE counselor to HSE assistant. The claimant's salary was cut. Moving to part 3, issues for the claimant or employee. Just 1. The respondent claims that the claimant is employed under a fixed-term contract of 3 years as per the claimant's contract. Response: the claimant's employment contract with the company was 3 years. The fact that the company told the claimant that she had a permanent job after her probationary period. And the evidence, the claimant wrote to the company on August 15, 2013, seeking clarification on her employment status. But on August 19, 2013, the company explained her employment. The claimant admitted in a letter to the company dated 8 March 2017, which she later repudiated for unknown reason, that she worked under the third contract. So, the claimant noted in her letter that the company's activities caused issues with her 19 September 2016 contract by filing claims against her on 31st January 2017. Next, charge 2. The claimant was being demoted from 30th 2 to 30th 3 in the company's organization, NAJAH. Response: the claimant's job duties were reduced from administering and assuring the HSE international program met requirements to conducting workshops and giving information at meetings. Second, the claimant was asked to make a weekly report of activities, student achievement, and next week's planning processes. So the evidence, the claimant's job changed from manager of international HSE program to HSE counselor of the company. The claimant was asked to write down that of what she did every hour on the time log sheet that was given to her and send it to COW5. Okay, last charge 3, the claimant's poor attendance result in disruption within company's operation. Response: at the relevant time, the claimant was experiencing issues with her health, including pregnancy, which result in her missing a significant amount of time from her job. And the evidence, during the period beginning on 1st March 2016 and ending on May 2016, the claimant was out of the office on maternity leave. Okay, so the claimant stated that she was victimized from the company after she returned from the maternity leave for her first pregnancy and announced that she was pregnant with her second child sometimes toward to the end of 2016. And between January 30 and March 3, 2017, the claimant was absent from work for a total of 22 days due to the medical condition.
Good days to Madam Hafizhah. My name is Goh Yong Seng and my lecture number is 20161. So right now I will be continuing for the presentations for part 4, issues for the respondents. So for charge 1, the response from the respondent is that the respondent stated that the claimant clearly knows that she was employed under a fixed term contract of 3 years, as the claimant did seek for clarifications on her employment status before. So for the evidence, the respondent had explained to the claimant via a letter dated 19 August 2013 that her employment status with the company was on a fixed term contract of 3 years when the claimant seeks for clarifications on her employment status via a letter dated 15 August 2013. The claimant also retracted a letter to the company dated 8 March 2017, where she called for a renegotiation of a contract of employment since the company's actions have created issues with a contract dated 19 September 2016 by making allegations against her in its memo for underperformance dated 31st January 2017. So this act clearly shows that the claimant knew she was employed under a fixed contract terms of 3 years commencing September 2016 until August 2019. So for charge 2 is weird because for this particular charge, the company did not provide any response or statements to explain why they decided to demote the claimant from a tier 2 positions to a tier 3 positions, which is from the manager of international HSE program to the HSE counselor of the company. For the evidence, the company also fails to provide any evidence to support their act on why they want to demote the claimant, so which end up resulting in a drastic change in the claimant's job scope. And next one for charge 3, the respondent stated that the claimant's poor attendance has resulted in the disruptions within the company's operations, as she was unable to commit to her work because of it. As for the evidence, the claimant's poor attendance, where she was absent for 22 days by taking medical leave between 30 January 2017 until 3rd March 2017, has disrupted the company's operations. The claimants also took the maternity leave from 1st March 2016 to 2nd May 2016, which also resulted in her poor attendance. So that is all for part 4. I will now pass it to my next teammate. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Adriana Binti Zamri. My metric number is 271463. Today I will explain about the solution to the issue based on Malaysian labour laws and courts. The first solution based on labor laws is Industrial Relations Act 1967. Based on Section 20, Subsection 1, the claimant believes that the company has unfairly disposed of it in breach of a jointly signed contract. The claimant has asked the company to correct the company's behavior in accordance with the stipulated contract, but the company did not provide an answer and the claimant considered himself dismissed immediately. The second law of Industrial Relations Act 1967 is based on Section 43(2), Subsection A. The company has revoked all the claimant's access to resources and data within the company without giving any notice. The company has also asked the claimant to vacate his office and hand over all his office keys at level 3 within 2 hours without giving prior notice. The second solution of labor law is Employment Act 1955. Based on Section 13(2), the claimant informed the company that viewed the company's aforesaid conduct as a breach of her employment with the company. Breach of contract by the company is: the first is the company abolished the claimant's position as HSE counselor and demoted the claimant to the position of HSE assistant. Second, the claimant was also informed of the pay cut or reduction of salary from 6,000 ringgit to 1,500 ringgit. The claimant requests the company to rectify the alleged breach by 12 March 2017, failing which the claimant will deem herself as constructively dismissed by the company. Second, based on Section 14(3), the claimant's plight seems to have befallen only after the claimant returned from the maternity leave in May 2016. The claimant said that on 11 May 2016, the company directed the claimant to relocate from level 5 to a small room on level 3 within the same day. The new office, according to the claimant, was congested with a diminished level of privacy without a computer and was inadequate to conduct counseling sessions in the discharge of duties. Thereafter, on 8 March 2017, the claimant was instructed to move office from level 3 to the ground floor beside the motorcycle parking area. The claimant gave evidence new office on the ground floor was exposed to noises and fumes emitted from the motorcycles, which was a risk to the claimant's health and pregnancy. Based on Section 15(2), the company via its letter date 30 March 2017 requests the claimant to show cause as to why the claimant was not present for work for 3 consecutive days, failing which appropriate action will be taken against the claimant. But the claimant did not respond to this letter. The claimant took 22 days of medical leave. According to the company, the claimant's poor attendance has disrupted the company's operation, but the claimant still gave medical certificate to justify the claimant's absence. The third solution of labor law is common law. First, employers shall have a duty of care. The claimant was pregnant for the second time after maternity leave. The claimant is an international HSE program manager changed to the company's HSE counselor position. The claimant was also asked to change her office from level 2 to level 3 within 2 hours. The new office was congested with a diminished level of privacy without a computer and was inadequate to conduct counseling sessions in the discharge of duties. After 6 months, the company instructed the claimant to change his office to level 1 or ground floor next to the motorcycle parking area. Claimant testified her new office on the ground floor was exposed to noise and smoke emitted from the motorcycles that endanger her health and pregnancy. This has proven that employers do not take good care of the safety of their employee since the employee is pregnant. Second, employers should have duty to treat employees with respect and trust. The company has issued numerous warning letters to the claimants for misconduct against the claimant. Each allegation given to the claimant has proved that the only allegation of misconduct that the claimant committed was unsatisfactory attendance. Even so, the claimant has shown evidence that she has a health problem. The claimant also stated that since the claimant reemployed after maternity leave and the company found out that the claimant was pregnant again for the second time, the company solved the fault of the claimant. This shows that the company does not respect and believe the claimant can perform his job well even if she is pregnant for the second time.
Code of Conduct for Industrial Harmony 1975. According on Clause 41, procedure for disciplinary action is, in the case of NAJAH, the company must provide a warning letter first for the claimant's offence related to the issue of attendance. However, the company has lowered the position and the claimant's salary is in conflict with the employment contract without disclosing the cause. Therefore, the company has been found guilty of the action taken against the claimant beyond on the limits of the first offence committed. Assalamualaikum and hi, my name is Hafizhah Binti Azeli and my metric number is 272890. I will continue to present about solution to the issue based on the case law. First of all, the case is between Tan Kok Chai versus Mega 9 Housing Senja Berhad. In this case, the claimant claims the salary or allowance or bonus payments from the company. The claimant has claimed about the non-payment of the fixed allowance, non-payment of yearly increment, not follow the term of bonus, no payment monthly salary, balance salary not paid from July 2018, and salary not paid from August 2018. The claimant claimed that he was unfairly dismissed by the company by way of constructive dismissal. The claimant also has said in his letter that he was leaving the company because the company had breached the term of his contract of employment by not paying him his salary, allowance and bonus. In this case, there is no evidence of any contributory misconduct as the company was not present in court and did not defend the claimant's claims and case against the company. Next, the case between New Products Sendian Berhad versus Mazuli Binti Mahmud. In this case, the claimant claimed the dismissal without just cause or excuse from the company. The claimant informed the executive manager that she was unable to work extra long hours on a daily basis as she previously did before due to her pregnancy, and pregnancy-related health problems. But the company issued the claimant concerning her poor work attitude and performance. Then the company terminated the service of the claimant with immediate effect. The company is sued for termination because the management has found the claimant are still repeating the same mistake, such as poor daily attendance, and also she are not performing her job seriously and be careless in performing the assigned task. The court is convinced based on the available evidence that the company had indeed no good reason to dismiss the claimant but had contributed one soon after the claimant intimated her inability to do overtime work due to her pregnancy. However, the court awarded her as a monetary sum as compensation instead. Last but not least, the case between Muhammad Faisal bin Muhammad Zain versus AKN Construction Sendian Berhad. The company alleged incompetency, mismanagement and misconduct on the part of the claimant. The claimant claimed that his dismissal was without reason or justification. The claimant claims that he received no warnings from the firm on his work performance. The claimant alleged that no adequate evaluation of his fitness for the post of site manager was conducted and that no advice was provided to him. The claimant's job title was changed to senior site supervisor from site manager. The monthly income of the claimant was also cut from 5,000 to 3,000. The employer sent a dismissal notice on December 11, 2008, terminating the claimant's employment with effect from December 18, 2008. The company were no reason given in the notice of termination except to state generally the based on the observation and continuous appraisal. The claimant's performance was deteriorating, discipline problems on his work worsening as he went on leave without informing headquarters and failed to cooperate with the management when the claimant failed to attend site meeting. The company said that respect of the claimant's incompetency and unprofessional discharge of duties that lead the claimant's misconduct. This court holds that the dismissal of the claimant was not made bona fide. Thus, the claimant's dismissal was without just excuse or cause. The court orders the respondent company to pay the claimant the sum of 15,000.
Right, so for the conclusion part, as for the court's decisions, based on the evidence provided by both of the claimant and also the company, the court is not satisfied with the decisions of the company to dismiss the claimant. And this is due to the fact that the company lacks the just causes and also excuse to dismiss the claimant. And because of that, the court has decided to interfere and orders the company to pay the claimant as the loss of employment, although it is at a slightly lower rate after deducting 30% because of the contributory misconduct. As for the group's decisions, based on the group's analysis, the facts of the case, the acts in the Malaysian labor laws, the codes and also the decisions in the case precedents, the group agree with the court's decisions to side with the claimant, because it clearly shows that the company had failed to provide any crucial evidence to support every action it made toward the claimants. So it just makes which makes it lacks of just causes and also excuses. So that is all for our group. Thank you very much for watching it.